discussion with 4 Lancaster juvenile judges and moderated by Andrea Corey. The Lancaster Juvenile Court began requiring that children attend their review hearings at least every 6 months in their courts. Judge Heidman, Porter, Ryder, and Thorson will discuss their impressions of children's participation and will provide recommendations to make the process smooth and beneficial for children and for the court. Before we get started, let's meet the judges sitting on our panel. First, Judge Linda Porter has been a separate juvenile court judge in Lancaster County since 1999. Before that time, she was a deputy county attorney in the juvenile and criminal divisions of the Lancaster County's Attorney Office for approximately 10 years. After law school, Judge Porter worked for a federal judge as a law clerk in the Southern District of Ohio for 2 years, and with a large law firm in Cincinnati, Ohio, as an associate for 4 years. She graduated from the University of Nebraska in 1976 with a bachelor's degree in Spanish from the University of Cincinnati College of Law in 1981. Between college and law school, she worked as a social worker in Berkeley and Oakland, California. Next, we have Judge Reggie Ryder. He has been a Lancaster County separate juvenile court judge since 2007. He has received his JD from UNL College of Law in 1997. Then we have Judge Tony Thorson.
I would say there's more to that. I didn't get the request to send in more. I wanted to keep it short for you.
Appreciate that. Then we have Judge Tony Thorson, graduated from UNL College of Law in 1977. He served as the Deputy County Attorney for Lancaster County from 1978 to 1989. In this position, he handled cases in juvenile court as well as prosecuting domestic violence, felony sexual assault, and felony drug cases. Judge Thorson was appointed to the separate juvenile court in Lancaster County in 1989. She was also my juvenile judge when I was in the courtroom. And then last but certainly not least, we have Judge Heidman. He earned his BA from Benedictine College in Atchison, Kansas in 1984. Then went on to complete his JD at the UNL College of Law in 1992. After serving as partner for the law firm of Morris, Titus, and Heidman, Judge Heidman was appointed to the bench in 2006 by Governor Heinemann. He is currently the lead judge for Lancaster County's Through the Eyes of a Child team. Please help me welcome these wonderful judges to come out and applause.
I just have to say, this is probably the first conference that I've ever attended where approximately 4 of the workshops have to do with involving kids in their court hearings. I think it's incredible, and it speaks volumes about this state that you're placing such great importance on how to do it right, and the impact that on kids being involved in their court hearings. And I think that I was going to say the most important people, but I think actually the most important people to hear from are actually the kids. To hear actually about what the impact the court has on them. But after the kids, I think the judges are the people that we should hear from. What kind of impact it has on them, how they want their courtrooms operated, to have kids come to court. And so that's why we have come here today to talk to the 4 judges about how it's worked in their courtrooms. So how this is going to work is I'm just going to ask a few questions and have each of the judges answer those questions, and then I'm going to open it up to the audience. But please feel free, even during our question and answer, if you have thoughts, if you have questions, to please, and feel free to put your hand up, and I will call on you. So that's how this is going to work. So the first question is just finding out what led your county to choose to have children attend their court hearings. Judge Porter, maybe?
Actually, if I can, I'm going to defer to Judge Thorson because she was part of a subcommittee that did that.
Sure.
So I'm going to defer to her on that question, if that's okay.
Well, I think it was basically through the eyes of the child. I think that we identified what our priorities were in terms of things that we wanted to work on. This is one of the areas that was identified that we wanted to look at. And I think a lot of the stakeholders felt that we could enhance the court hearings if the kids could actually be involved in a more consistent basis. It wasn't that we've ever included kids from county, but there wasn't really sort of an orchestrated effort to get children. So I think that was probably the main issue there that caused us to try and make this push to get kids to come to clear.
Well, then also at the Children's Summit in Nebraska City, there was a panel of youth, former foster youth, and we also saw a video that I think kind of struck us all personally also. We are impacting these kids' lives, and we should do it.
I think that was real powerful in Nebraska City. Why shouldn't we try this and see how it goes?
I was an Nebraska City. That was in '96. Or '06, I'm sorry. I came out in '07. But I do know, though, from an attorney perspective, I've been to other training sessions before through the guys, and we've seen a similar video as far as from the foster youth, and they've been discussed, not real, as if we were going to try to adopt it. It's been discussed, and there's been a lot of discussion back and forth, pros and cons. So I know it's been talked about for even well before the '06 summit that I wasn't at.
What kind of preparation, if any, did your court do to prepare for the kids coming to the court?
I think the subcommittee sort of developed a kind of protocol, but some planning for it. Caseworkers were all put on notice that starting a certain day, or a certain month, first of the month or a certain month, and we gave them some lead time, I think it was at least a few months, that for all review hearings, or disposition and review hearings, children were to be brought to court, and they were to make arrangements to do so. And I think that they were responsible then for letting the foster parents or transportation arrangements or bringing children themselves to court. But I'm not sure, and attorneys, did we send a letter out to attorneys advising that we're starting this practice? I think so too.
We talked to counsel.
So judges are across the board also, regardless of age.
Yeah, you're right.
Result goes there,
Yeah,
disposition.
but we did talk about the guardian ad litem being someone that could excuse or waive the child's appearance if the child didn't. And we started out, and I think we're still that way, pretty lenient. If kids don't want to come to court, we aren't going to force it. They've got a school activity they don't want to miss. The last thing we want them to do is have to go to court instead of be a normal kid. Or if the child's therapist thought that this was, they were terrified of the prospect, this would be a bad idea, but kind of let the guardian ad litem be the one to waive the child's appearance or ask the child's appearance be waived. If we didn't go through a real formal, you got to file a motion to excuse the child, kind of been pretty informal.
And I'm curious, did you ask the parties at the start of the hearing if the child was present? How does sort of the hearings go, trying to find out if the child's going to be there?
Obviously, the smallest was pretty obvious. I think we would have parents, guardians that identify their children in there. Of course, then that would bring up the issue at some point in time, in some cases, there may have been issues that were going to be addressed in court that the parties felt that might not be suitable for children here. So we kind of worked with making adjustments to the hearings that we maybe take up their issues first, ask them if they had anything that wanted to let the court know, and then we could excuse them from the courtroom so those other issues.
We kind of give the children the choice of whether they want to sit at the table next to their guardian ad litem, or at the table they can do that if they prefer to sit in a couple of rows of pews in the back. If they want to sit back there, they can.
Anything else, any other sort of preparation, anything that the court had to do? Any change in how you call cases, any change in anything else with the court's structure?
The only change I could say is, I don't know exactly how the other judges do this, but, I always let the child have the last word before I say what's going to happen. So in these hearings, there can be a number of attorneys and parents, and it can take a while to get around the table, but I always will say to the child, this leave them for last because they have the last word about them. So unfortunately, they're not always very comfortable in terms of, they're nervous, and a lot of times we don't get much information out of the youth. But so if they do have a lot to say, that may just, I would say, as far as impact, it may cause hearing to be a little bit otherwise, as far as the changes we have to do, sometimes just holding in another chair or having them come forward, but that's not going to change it all.
What do you see as the advantages for having a child there?
I now have a face that goes to the name, and, you know, when I was seeing kids that I had on my caseload for 3 or 4 years in an adoption hearing for the first time and actually seeing it, we're people, and until you see something in the flesh and blood, it's just a different experience. And so, I think it has the same impact on the attorneys. A lot of these attorneys, these guardian players, never really met these children. Even the babies and the 2-year-olds, they may not get a lot out of the hearing, but I see them, and then I see them 6 months later or a year later, and they're a year older. And I think that's just very powerful.
And I think the older kids also have something to say. A lot of them have a position, and they're given an opportunity to express, this is something I want. And not everyone takes advantage of that, but the kids that do, I think that can be really helpful to get that information.
And that's an excellent point. And how do you make the child comfortable enough to sort of express exactly what you're talking about their opinions? Because we've talked to youth and they clearly want you to know what their opinion is. And so I guess I'm just curious to know how you as a judge make them comfortable enough to share that.
It's kind of hard because we do a formal setting, we're ready to confidential, but I think the thing primarily is just to say, we're glad you're here. This is about you. If you feel comfortable telling me something, I want to hear it. This is your opportunity. Just trying to, be like, I'm listening, be open. But, some kids are just very shy, so I'm saying, but then I say, if they don't have anything to say, I say, they're in your already tell them.
Maybe usually can find something in the case plan or that personalizes it to that child and make that connection that they don't know you have read something about them, you know what's going on in their life and recognize and open up that communication.
One of the advantages that I see is too, if you have a case, I mean, it's understandable, no matter what a parent's done, just about every child wants to go back to that parent and still loves the parent. I think sometimes it's helpful, we talked about the blame game, feeling like the child did something wrong. Well, sometimes by being there, if they hear what the difficulties are, what the parent still has to do or needs to do, it can give them somewhat of a perspective. This is why you're still in that place. It's not because anything you've done, it's because things that mom used to do, dad used to do. And I think, and for them to be part of the overall process and not wonder what happened in court. Most of them know there was a court hearing. They wonder what happened. If we have not very active guardians that lie to them, which unfortunately is pretty common. You're not going to have that person to call upon, and they just wonder and just not know what happened. And this gives them at least a sense of what occurred. And it certainly isn't entirely about them. It wasn't their best interest. That's a big advantage to actually see it and be a part of it.
You can also see the interactions between the parents and
That's true.
kids, and sometimes that.
Well, in fact, one hearing I have, one logistical change I made is I have a basket of my kids' old toys. Because I thought for some of the younger kids it'd be something they can be distracted with. It's quiet, soft toys. But one time I came to court and there was this little 4-year-old throwing around this Chuck E. Cheese football, and he was playing catch with all the people at the table throughout the hearing. He somehow made it through. So, that was probably a bad idea bringing the football, but I got to see the kid was a happy kid and how he was interacting with all the people. I wouldn't have been able to see that if he wasn't there.
Are there any negative experiences that you had potentially foresee or negative consequences of having it?
One thing I saw, this was kind of an early stage, and at the time I was an attorney for a parent, so when you're in that role in civil court, it's different than when you go out to the judge's door. And this was early on in the process, and I think some of this deals with trying to make sure people know all the dynamics of the people table, because it was evident that this young man at the table was very uncomfortable throughout the hearing. And no one could figure out why until afterward we learned he was sitting next to, this wasn't his father, but it was the father of another child, and he hated that guy more than anybody else. And throughout the whole hearing, he never sit next to him. And so I think part of that is you need to figure out some of those dynamics instead of just plugging everybody at the table. And so I think for him, that was not a very comfortable situation to be right next to him, part of that hearing, with this guy sitting next to him. Not me.
I think an unintended consequence was we saw guardian ad litem's then to consider that meeting the child in court to be their required visit with the child, that they would have to then go out and see them in the hospital in order to fulfill the requirements of Provost Western's Office of Elections Review hearing.
I think sometimes with maybe one and two, but they immediately gravitate towards the other, which is nice to see in that sense. But if they're being held and whatever, I've had to sometimes say, I think it'd be helpful for maybe someone to take the child out because it's distracting. It's really, and I want them to hear what's going on. It's too important. And 1 and 2 year old I haven't seen for a few days. It was very, so that's a complication. I wouldn't say it's a negative or a disaster, but it does. You have to. You'll either change the hearing if you want it to be. Sometimes I want to really talk very frankly to the parent at a certain point in time and just have the child on the left.
And you feel comfortable though, asking the person to come in and take the child?
Yeah, and we do that all the time. I've had some cases where, the guardian ad litem's asked to have a 12 or 13-year-old excuse, and I say, for 12 or 13-year-old, I said, "You want to stay?" And they want to stay. I'm just going to stay. They're entitled to know and what's happening. I think, it may alter a little bit some of how people question, but really young, sometimes they are 7 or 8, or something that could be distressing. Sometimes we excuse them, as long as there's somebody to watch them outside. Any experiences?
I was waiting for this question. The only negative, I guess the negative would be, I had one with her mother just sort of happened, one mother had an absolute meltdown, and that was just really hard for the kids. Although I'm sure there's some other situations like that. The one thing I had not thought of was potential for people to be arrested. So we had one where a mother was actually, she was a person happy, the mother was actually arrested, and I was really upset with the child. This was like after the hearing. And then they had.
Can you speak up?
Oh, sorry. Seeing the parent arrested. And so I think the caseworker actually brought the child through the door they're never supposed to bring the parent through. Just to kind of get the child out of the way. That's something, it's never happened again, so I think that the insurance wait. I think the thing is you never know what's going to happen, especially when kids are involved, so you have to be prepared for the unexpected.
Right. And I think that's why we teach a lot, that we have to prepare the youth for coming to court. But I think that you're absolutely right. You can only prepare for so much. Things do happen. So that's why it's equally important, always more important, to talk to the child afterwards, to process what happened, the child seeing that incident with mom. How do we process that with kids afterwards? And then get them into counseling if that's what's going to be required. So any great experiences that you've had, anything that you could share with the audience that are kind of a good story?
I guess one thing I want to say before we get to that, I hope that with 3 of the youth that were on the video who are here, I'm glad you're all here, I hope at some point during this they get a chance to talk about. We saw it on the video that, as we said at the outset, it's best if we hear from you guys, and you guys are here, and that's great. So I hope at the end you say somewhere along the way you say anything that they want to say as well. So they've been through it. that was something I just wanted to.
Well, I went part three, but it was powerful. And it was right at the outset that we started reading this recording. It's a case that I have for 6 siblings. And I'm sorry.
Judge
we
Porter,
can't
I'm
see
sorry.
that.
There's a
I'm
fan
sorry.
right above us, and
It was
I
a
think
case
it's the
we
fan
did
that's
that I had
causing.
right at the outset of when we started bringing kids to court, and it was 5 or 6 kids in out-of-home care. And a mom, I think at the time was incarcerated, but was transported. And one of the little girls, who was about 8 or 9, I always give children a chance to say something at the end of the hearing of court, and if there's anything they want me to know or the parties to know. If they don't say anything, I try to at least draw them out and ask them about school or the things they like to do, or something in the court report that's triggered, so that they at least get a comfort level. But some kids, you'd be surprised, they will just tell you what's on their mind. But this little girl, she looked at her mom and she says, I want to know why you don't show up for visits. Why?
Could you repeat
And
it?
why won't
Could
you
you
show
repeat
up? I'm sorry, she said, I want to know why you don't show up for visits, and why they take us to the visit and you don't show up. And the mother just broke down and sobbed, but it was totally powerful, and I'm convinced it had a role in her relinquishing parental rights not long thereafter. She was going to face a fairly lengthy prison sentence, but it was powerful to that little girl, and her siblings all looked and nodded, and his attorney was livid at the time. I mean, he came up and gave me a piece of his mind about having kids in court, but that's why you should have kids in court. Well, it was something she probably needed to hear. So that was interesting.
Any other good experiences or otherwise?
But for me, the best thing that I've been able to experience is when there's a child in court and the decision is made for him or her to go home. And I get to tell them that, and since they're at the end, I usually ask them if they have their bags packed and how long it takes to get them packed because they're going home. And so that's, to me, one of the best things about them being there is they don't have to be in school until later. They know right then and there. They can wonder if they know they're going home. There's their parent. They're going to go home with them. And that's one of the best experiences that I've had with it being there.
I think too, some of the older kids, too, those who were on the film, that can sit there and be so articulate and express things that are really hard to say, sometimes weird, and to sit there and say things in court is just amazing to me. The kids can actually do it. So it makes sense.
But it's disappointing from the standpoint too that I think if guardian ad litem, especially if it's given a little bit extra time and get to know the kid better and know that information ahead of time, that stuff wouldn't have to be brought out. They can have that information already. But still, their ability to articulate where things are at. But also the other amazing thing is I've seen a couple times are issues that attorneys think are a really big deal concerning the kids. When it's brought up with the kids, that's this was just.
So actually finding out what is important to the child. So, yes, Bob?
We usually don't call kids to testify in juvenile court, a lot less than in criminal. But I did it for the first time, and I'm an attorney for partner with the case of Judge Porter, so it's now no longer space. It was a motion, it was a placement change motion, and it was an ICWA case, and this guy was 15, he was really a pretty remarkable kid, and in my judgment, his view and testimony was pretty important pretty important evidence to put on, and he very much wanted this placement change. But I met with him ahead of time, and we went actually to Judge Ryder's court, because we were in session and watched, so he could see something going on in the court. And then I gave him the choice. I said, I'm not going to make you do this. this is your choice. I explained, and he was old enough to understand what the issues were, what it was all about. But when we were sitting there on the bench in Judge Ryder's court watching, because he said to me before when we were meeting, I don't know if I want to. He whispered to me, will it make a difference if I testify? And after I said to him, I can't assure you of that one way or another. I think it might. But it's still your choice. But he chose to do it. I think he felt very empowered by that experience. And that he really got a chance to say how he felt about foster care and how he felt about where he wanted to go. I think it was a difficult thing, but very empowering for him.
Absolutely.
And I don't know if I can talk that way into whatever was even necessary, but
Well,
it was a
I
close call.
think it might make it different.
I think
it's real when you hear it directly from a child, and you learn a lot about a child. It was a very extraordinary child.
It was a hard motion.
It's not a negative.
Yes.
On that, so far what you've done, is what you said, is have the child at the end share, speak out loud, public speaking. Do you think, based on that, that guardians ad litem should be encouraged to call the child as a witness in a very, I'm just asking, like a way to find out more information or to share the additional facts that aren't in the case planning court report?
I don't necessarily think so, because then they're kind of led by the questions that are asked or something. I would hope no one's going to attack the child and ask them rigorous cross-examination, but then they're kind of they're limited to what the questions are. And I think, to me, it'd be better if they're just given the open forum. Others may disagree with that. That's, there may be times to do that, like Karen talked about in a particular case, but I think generally speaking, I think the guardian ad litem will be better to talk to them before the hearing, prepare them for, this is going to be asked, at the end of the chance to say anything you want. So maybe be thinking about it during the hearing. And you don't have to say anything. You don't. Some people aren't comfortable with that. We understand that. But if there is anything you want to say, you're thinking about it, no one's going to ask you any questions, you just can stand up, say what you want, and then sit down. That's my thing.
I did have one case where the child basically just banded and let loose with, here's what I think about mom's husband, here's the problems he's caused for us, here's all the things that have happened to my little sisters, and their inability to sleep, and on and the parent's attorney for the dad is like having a meltdown, because there's someone that's not being controlled at all. There's no objections. There's no, they're getting a total open forum with access to tell me anything. So that at the time afterwards, I said, well, that, I responded. That's why you never know what they're going to say. And this went on for quite a while. And so I gave them an opportunity to ask, if you have any questions, you want to ask me. Give them an opportunity to not have any questions. They do, and I suppose, that's really not evidence, but it was pretty hard.
If guardians ad litem actually met with the child before the hearing, a week before or whatever, and prepared for the upcoming hearing, it seems like an appropriate focus of that discussion ought to be the guardian ad litem saying, this is what I think is going to happen at the court hearing, or here's the court report. Maybe it needs to be closer to the hearing, and this is what's being recommended. What do you think about that? And then the guardian ad litem talking to the youth about, is there anything in this that you disagree with, or you want to have, I'm kind of what Karen, I don't know if Karen's thinking, that might be one for the placement change or whatever. And the guardian ad litem in our state, needs to be representing the best interests, not just but they're supposed to be doing both. So, and only divert if it gets messy if there's a inconsistency. But to me, it seems like that there might be both the court, asking some general questions, but that oftentimes the guardian ad litem might either present some other evidence, or if the child is willing, have the child, speak to something that the child might want to have the court order or decide. And I guess having sat through court a lot, I mean, that doesn't ever happen, that a guardian ad litem is actually trying to have an impact in what you hear. I mean, maybe they're doing it in the reports, but based on losing the child or based on the child trying to have an impact on the court's order at a review hearing. And
Absolutely. I mean, the guardians of, their role is to advocate for the child, and if there is anything in the report to the court by the child welfare agency that the child does not agree with, that should come out. If there's anything that the child wants to be ordered that isn't in the report, absolutely that is the role of the guardian ad litem to bring that out to the court. So I think that they're excellent. I want to ask the former foster youth who are here just about any thoughts that you have. We have been kind of just talking about sort of why it's important for you to attend. So any ideas that you have, what it does for you to be present in that? Any thoughts? And you don't have to.
I don't know, they have a lot of the topics, especially with seeing it themselves, so we definitely want to be seen, we want to be heard, we want you to put a face with us, because like, if you have a kid in the system for 4 years, you see how much that kid's grown up, and you're like, wow, we're slacking on this case, they're not home yet, we need to do something. And just kind of put a lot of
Yes.
I just had a comment, as we're talking about hearing from the children, and I agree wholeheartedly that they should be there and they should comment. And our judge, the 8th District, Neil, will always ask it at the end. But we've got two different things going on here. If you're looking for evidence from the child, you've got to call them, they've got to testify.
Well, I wasn't looking for
No.
evidence.
You got some, but you weren't looking for it. But, most of the time it's a review hearing and there's no objections, and then the judge doesn't have a routine, says, well, you have something to say, and that's a great thing. But if there is a controversy or there's a matter of issue that the court's going to have to make a ruling on, then if we're asking about whether the children should become a witness to obtain a result that may be contrary to maybe another parent might not want or something, then what do you think about that? Because now you're talking about calling the child as a witness in an adversarial proceeding. And I know how our district, some of us lawyers out there do a lot of enforcement too, and I know how my district judges feel about bringing children into court and having to testify in contested custody matters. And I'm wondering what the juvenile bench thinks about having children testify about contested issues. Well, I would suppose placement would be that'd be an obvious example, because of course in Nebraska, if you're 14 or over, you get a sign off on a guardianship thing, and you're talking about placement. I think if somebody's 14 or older, they are no better to be given a chance to say if they want to be someplace different than somebody else.
I've never had anybody, I don't think, since kids have been coming to court, asked to have them testify in terms of that proceeding. The placement change, the parent reference, yes, but really, children, most of them are not called to testify. So you may get something that.
In this particular case where the things that were being said, probably hadn't been really said before, it might have been, I gave everybody an opportunity, would you like to come on, call her as a witness? So I wasn't going to call myself.
Yes.
A lot of work has been done to increase the connection between foster parents and bio parents that care of a child. Any dynamics that we've seen with foster parents and bio parents in court, foster parents bringing the kids to court, and
That is kind of
how does that
interesting to
dynamic
watch.
work?
It's interesting to watch, like if their baby cries and getting it off to the foster mother or something. You kind of see the cooperation.
Another question, what role do you see as a judge to explain the process to the child, explain your ruling to the child? What do you see sort of your role in that?
Well, I think when kids are there, you naturally gravitate towards less legalese. Parties do too sometimes. I would say sometimes the question with the caseworker by attorneys is softer when the kids are there. But I view a lot of that, I think some of it's time. Most of us run really tight calendars, so you don't have some of the time you might like to slow things down so that it is understandable for the children. But I really do view that as a guardian ad litem's role to sometimes afterwards explain what happened if they have any questions or don't understand what happened. But I will say, I think I do try to explain a little more clearly what's happened or what I'm ordering. And certainly if the kids have questions, and they will say, are we going to have monitor visits? Or what does my mom need to do to have monitor visits? And you try to respond to that. I think it's fair not to try to respond on something. So I think the guardian ad litem should do the post after the hearing, not to say, debriefing or whatever. The postmortem. That's the word I was looking for. But explain what happened if they have questions.
I agree. I think it is, we are very formal even when they're there. Sometimes it is time, it just kind of limits how far into it you want to go. And I will sometimes, if they're trying to explain what the things need to happen, and I talk to the parents about this too, so that they understand what they need to do. And as far as directly explaining it to the child, I don't know how much I can change it significantly. Pretty much what I said.
If you had a child in the courtroom that wanted to say something to the judge, but was very, very uncomfortable saying it in front of mom and dad, do you make any allowances for that?
Well, this happened just a few weeks ago. But the guardian ad litem in that case has done a fairly good job of knowing ahead of time that the child wanted to say something outside of the parent's presence. And she indicated that at the beginning of the hearing, when it came that time, then asked if anybody had any objection to it, or if they wanted their attorneys to be present, but go in chambers. And everybody said, no, we're fine. You're on your way. Had a good conversation. And you said, was it recorded? No.
You know, one thing though that I've seen it's a little bit different than that. But once in a while there'll be a letter written from the child or the children, and if they send it to me directly, I cannot just, I can't receive any ex parte communication, so I can't consider that. So we send a copy out to the parties. But I think if they were to have it through the guardian ad litem, they could write a letter if they wanted to, especially if they're not comfortable talking in court. They can do that. They can write a letter. This is what's going on. But it does require the guardian ad litem to be involved and willing to do that. And sometimes we'll get letters from any other, not just the child. We'll send it out and we'll never see the letter offered at any of the hearings. It's just go in the file somewhere as part of the proceeding. It's not offered it out, so we can consider it. But that's certainly one other vehicle that could be explored in terms of information that if we're comfortable saying, understanding the parent's going to get a copy of it, understand what's written, that might be a separate issue that you have to deal with. But at least if they want it to be heard, whether it's nerves or just don't want to say that's another option.
We need a CASA.
Yeah, the CASA will do that.
But your question before that, explaining the process, I think there's a benefit once in a while too, if we're doing that with children. Sometimes our parents are not the most articulate. I think once in a while we can step back and just kind of get away from all the legality and kind of explain things. They seem to have a better understanding of what they need to do. There are times when you just go through the road making everything what you're doing that we're kind of sitting there with the deer that way, but maybe not fully understanding also.
Yeah, we had two little girls some years ago who we had to prepare before they came, and they really needed to know what they were coming to. So they told their CASA volunteer that they'd seen Judge Judy and there was no way they were going to come. So we actually arranged for them to come to visit when court wasn't in session, and and they sat in a big chair and they looked around and we told them where mom would sit, dad would sit, and everybody would sit, and then it was a whole lot easier for them to come. It actually happened. So I think sometimes you have to do that. Press work, make it work.
Absolutely. Yes.
I'd like to tell you about my best experience with having children in court. I'm a guardian ad litem from Gage County, and we had a case where the parents were arrested for selling and possessing drugs. And we had a pre-hearing conference before that, and I asked the kids to be there, and of course the parents' attorneys objected. They didn't think that the kids, this was early on in the process when we first started this. But anyway, children were a little bit late, and we had started the meeting, and the parents were very defensive. They weren't going to admit anything. They didn't do anything. They were mad at the police. They were mad at everybody. And all of a sudden, the children walked into the room. Their foster parent brought them. And all of a sudden, their attitude changed totally. They melted down. They started crying. And they decided that they were going to cooperate and work with us. And they admitted that what they had done. They admitted the allegations of the petition. And ultimately, the case was resolved in about 6 to 8 months. And these were teenage children. The one boy was flunking out of school at the time. He started college this year. So the parents made 180% turnaround.
A lot of people talk about criteria for having a youth come to court. And you were commented at the beginning that kids of all ages come. So I guess age being one of them. What are some of the criteria that can be put into place or examined when a guardian ad litem is trying to decide if a child should come to court? And is age one of those things?
I think any child, no matter what the age, should come, because even if they're not verbal, we can get, seeing that child is helpful to us. So I would like to have any child, and from the older ones obviously say things. I don't know that there's any other criteria. I guess there are certain times when the nature of the case is such that if the child has been violently or sexually abused, they may be not want to be there. So I think that would be something that would have to be explored with the child. If the person that was responsible for the abuse is going to be there and the child felt uncomfortable being there, then I would not want to say, okay,
Or if there's a no contact provision out of a criminal case, that would be a basis to.
Well, how would you handle that? And that's an interesting point. So there's a no contact order between the parent and the child. The child says, I want to come to court. And the child, let's say the child is a teenager and has a good understanding of what is going on in the case. How would you handle that?
Well, I think you could probably set I've never had it come up. I mean, I wouldn't want to violate, I don't think we can violate that, because the child should have an opportunity to be heard, I suppose. And if the attorneys were all agreeable to their clients being excused from a hearing, and you set a hearing with their representatives there, but then, and that's the easy route. If they are not of that mindset, there might have to probably say, we'll do it as soon as the contact provision.
Of course,
I think there are kids, people that have no contact provisions that are in court all the time.
Yeah.
And I don't see any difference between that and the child, but I think what you have to do is take some steps to say, okay, we're gonna make everybody from the parents come in, at different times, then we'll excuse the child and let the child leave so the child doesn't have interaction outside the courtroom. I mean, that's what I would be worried about, not so much in the courtroom.
Right, but how it works.
Yeah, because I really don't think that's a violation.
Other thoughts about either age or other criteria? And I think that I want to re-emphasize this. A lot of people, both here and across the country, don't think the court is a place for infants and toddlers. So that's just not appropriate to recognize. The point, Judge, is an excellent one. That infants can be brought, toddlers can be brought to court for the benefit of the judge, to actually lay eyes on that child, to see the interaction with the child and the parent or the guardians will. And so I thought that was good.
I think also too, I mean, you can say to the parent that especially if it's an infant, you can say, you know, I've seen your beautiful child, you know, and you can say, you know, we all want this child to have a good life, and you know, I think that can, you know, come down to the parent too, I mean, that's something
Yeah, this is an answer, one here.
In Lancaster County, the CASA program offered to the department, if caseworkers knew that they were gonna bring kids to court and they're toddlers and likely to be screaming around or, you know, taking their action figure and pounding them into the benches, that, we had some inactive volunteers who had already, you know, been through all of our training and all of that, that offered to be on call then to come to court and, you know, after you'd seen the children, be able to watch them out in the waiting room. We've never had anybody take us up on that, but generally we also have a staff person there with the volunteer, and I know several of us have gone out in the waiting room with a 3-year-old and, you know, just provided that opportunity because it is important, more important that the kids are in court.
And I always have crayons and color books and pads and papers so that, you know, certain ages, that's, and particularly if there's not anybody to sit with them outside or if they can hear it, I can draw a picture of it.
And not have the action figure pounding.
No, you have to draw the line at chocolate covered donuts and chocolate.
That created a little bit of a mess.
Right. Did you have any
Well, I was
follow-up to
thinking-
that? I knew that you wanted to.
I saw that the judges had done that when I went to court with them, and that made a huge change, just like that attitude of bringing things for the child to do. But I see that there's some remodel, and I was wondering if the judges had thought about the lobby and how, if there was any restructuring or thinking about, you have a lot more children
There is.
coming in, how did you plan for that, or thinking?
There is, and we thought about that. There's going to be kind of a half wall back far away where the kids can go and kind of be. So we do have that. We'll see how it turns out, but on paper it looked like that would be a good resolution because we did think about
The waiting
it.
room's
Right now, our
gonna be
waiting room is very small.
3 times as big.
So I think as courts start to do that more and more, your dynamic of your lobby area where parents and people are, that might have to change, so I think that's.
Steve,
Is there any differentiation between the type of hearing? Easy one is having them come to the review hearing, for being more difficult one is having them come maybe to the first hearing or the trial where it's either because of the length of the hearing or because when things are first starting out, that's generally when things are most contentious. Do you guys differentiate at all on that or not?
We said disposition.
Disposition and reviews, but no more than every 6 months. We don't want
Okay, but you're not having them come into the trials of the first hearing? Okay.
And I would not want them there at the advisement of the TPR, the advisement of rights.
Yeah,
Yes.
Recommendation on what the trustees said earlier about putting the things to a name on, like from the kid's point of view, it's kind of like feel like more important. Like from like if you don't see your judge and you just hear what happens, you know, I guess on the video a lot of things get left out or misworded if you just pass it through people. And so if you just hear what people say, the judge may sound like a bad person, like the bad guy. And then if you go to court and you see her and she's like, oh, she's not that bad.
And they were pointing up there.
I can't tell you how many times throughout foster care that I felt like alone and just a number, just a statistic. And then you go and your judge sees you and you voice your opinion even if it's through somebody else or through a letter. You know, it just makes a huge difference in the eyes of a child or a teenager, whatever you want to call us. It's huge from our point of view. And I know I speak for a lot of people and I say that we really appreciate being able to come to court, whether it's just a review hearing that takes 10 minutes or if it's, you know, something that's going to be a little bit more emotional. I mean, we want to be there, we want to see what's happening. Because we don't want to wait all day at school, you know, not being able to concentrate, not being able to do our homework to see what's gonna happen. You know, we're talking about us, and we want to be there because we are who we are, and it's gonna ultimately decide where we go, what happens. And it just makes a huge difference. And I know I thought Judge was pretty bad, but I should have
I have a question for you. Like when you indicated here on the video about knowing there's going to be court, how did you normally find out there was going to be hearings? And who let you know when the next? How did you find that information out?
I didn't really have contact with my guardian ad litem, but I had an amazing CASA worker, and my caseworker was usually pretty good about calling or going out to lunch, having something lunch, and we would just talk about like, there's a court hearing here, and it's going to be about this, and you're more than welcome to come if you don't want to come in this situation, it's fine, but it was always usually through my CASA worker, because me and my CASA worker talked a lot more than my caseworker did.
How did you find out?
I was sure my place was seeing professional in my group home. I never very much what did and saw her like maybe 10 minutes of it. I saw her, but I didn't have a password.
So someone just let you know.
They're like, oh, or like I was since the very first day I was in my father's home. And she's like, yeah. She called me to school and I was like, and she's like, court? And I was like, what? I was going to court? And she's like, told me what it was about. And like, and then after that, then I kind of guessed there was going to be here.
Sure, sure. How did you all find out you had court hearings? Who told you?
My caseworker did all of them.
Caseworker. And that sort of leads me to another question for the judges about how do you try and ensure that the kids are going to be in attendance? We kind of talked about at the beginning. You asked, if there is a child present. But how do you, with this new push to really get kids to come to court, how do you ensure that occurs? Or do you?
That's probably one that I think we haven't done a very good job after we kind of got things off and running. Department, I think we got them on board eventually to have children there, and then the caseworker comes over and just as time went along, that priorities kind of been neglected, so that's something I have to stress again.
So how do you think that you would do that? How do you think that you could sort of
Well, part of the problem, I think, when we started it is most of us, for children that were placed outside the home, were reviewing cases more often than every 6 months. And we didn't want to keep pulling kids out of school or requiring that they be brought every month or two, or depending upon when we were reviewing it. So, but now most of us have gone to a more 6-month review hearings. So lately, I've just been asking, where are the kids? Yep. And the caseworker looks at me like, oh, was I supposed to bring them? And I said, yeah, I want to see them at least every 6 months. And you can, if the child doesn't want to go, or there's a real good reason, then talk to the guardian ad litem, because they can waive their appearance. But it is something that's kind of fallen off. And so I'm just trying to now, if the kids are not there, say, where are the kids? If it's been 6 months since I've seen them. And I try to put in my order if their kids are there. That reflect the appearances, so that I know when I last saw them.
any other comments?
I do the same thing. I put it in the order, and I'm trying to say, well, I expect them to be here next time.
Yeah.
Because I also think there's another push not to continue hearings. So I guess that would be the ultimate thing that we can do, is say, well, we're not going to go forward, then we expect the children to be here. Then I think, there's negatives, obviously, to that too, if we don't get to do business, because we have to continue it. So I just encourage people to bring it next time.
Well, maybe with the privatization, the caseworkers will have more time.
There you go. Or maybe the guardian ad litem's good.
That's an idea. Do we have to have the judge's permission to bring the kids into court?
No, not ours.
No.
Some judges you might, I don't know.
Well, they're all open to the public.
Yeah, I know.
And at first I thought it was going to be really hard and awkward to ask to have children excused, because sometimes I'll have some questions and I just want to get real frank answers or whatever, but it isn't usually. I just, call the attorneys up and say, is there any problem with excusing the children? The only wrinkle that happens is if they're young and there's nobody there to watch them, they either came with their parents, because we have kids come to court even if they're placed at home. If there's nobody to watch them, that's the only thing that happens, but that hasn't really been bad. And really, we don't excuse kids very often from parts of the hearing, I would say.
So do your court orders, when you order the review hearing, and like it'll say at the review hearing, such a date, and all parties are expected to be back here, or be here, you don't include and the child?
I haven't.
That would fix that.
We could.
It would.
Well, it might.
And then a lot of times
Assuming they read the order.
well, right, they'll have a child come into court maybe just for a few minutes, and the judge sees them, and the parents will be noted, and the child is here, and then they'll say, now can I have the child taken out to the nanny room or something? But anyway.
But you're right, that you could add that.
Put that in.
And, yes.
I would encourage you to rethink your position about having kids come to the first hearing, because I think that it changes the whole tenor of the case. If the kids are there at the first hearing, I think the parents are more cooperative. In our county, we really don't have that many contested adjudications, and I think it's because kids change. When the kids were there at the first hearing, parents and everybody realizes the focus is on the kids, and it changes.
And it also gives the guardian ad litem the opportunity to meet the children. They're supposed to meet them within, right, well, they're supposed to meet them within 10 days under the statute, but I'm not sure all of this. But
Can I comment on that? I think they should be there no matter what personally, because if they're gonna change what they're gonna say within the first court hearing, who says they're not gonna change what they say with any other court hearing that they have? Like, they could just be like, it shouldn't matter which court hearing, they don't want to hear kids to hear one thing, and very personally, they're not gonna hear the whole time they're at court, any other court session.
I want to give each of you an opportunity to just kind of, again, any sort of overall impressions of kids coming to court, good, bad, or any advice.
Well, one thing I would say, I know Vicki Weiss is here, and I want to plug her thing tomorrow, because we had actually done a study. We didn't do a study, we just did our thing, and they were there. But they did, it's not scientific, and you can do your disclaimers tomorrow. Maybe it was scientific. Okay, it was
some limited.
okay, all right, it was, okay, well, they did the study, and they're gonna talk about it tomorrow, and they interviewed the kids that came to court, they interviewed kids that didn't come to court, and they had some pretty good results, and ultimately the bottom line was that they concluded there wasn't any harm that was from that coming to court, and there was some benefit, a great benefit from coming to court. So my experience has been it's a very good thing to do, it's a very beneficial thing. It is about the kids, and that's what we're there for. That's why the petitions are in their interest, and that's what we're trying to figure out what's the best thing to do. So I think it needs to continue, and I think we need to do a better job of finding out why they're not there. And it is an excuse. It's not a good excuse that we do get busy and we don't look ahead. We can see that they weren't there, but ask them why aren't they there? Is it when we bring them there, and if we come back in 6 months, we miss half of the year. I've seen them and hear from them and give them a chance to be part of it. So I think we need to probably do a better job of making sure that they are there, whether it's including it in order and hope that it's read and followed, or some other system of notifying them that they need to be at the court meetings.
Sort of last impressions of
No, I'm still amazed at kids whose lives are in chaos, and when you come into that, you come to say, and people start to do it. Something I know we do.
I agree with what's been stated. I think it's really helpful to us. It kind of puts the priority where it should be, actually seeing the children that we're making decisions about. And the one thing I guess I would say is you have to be prepared for anything, because kids are so honest, and if they feel comfortable enough, they will tell you what they're thinking. And there's a lot of people that filter that a little bit. So I think you have to be prepared for them to say, well, if I'm not going home, why am I not going home? And that's what happens.
really, I echo the comments. I don't regret being here at all. It's years and they actually see them, and with no movement in their case, it will prompt them to take a look at what should be happening in the cases. It hasn't really been a nightmare. It requires some adaptation, but I think the benefits far outweigh its advantages, and I encourage other courts to try it. There's a downside. If we were gonna try it at all, and you don't wanna do it wholesale, these kids over time, this is about them, and we forget that. And it also helps them, I think, gain some respect maybe for the court process of realizing they do care about them. And sometimes I've had kids say, you know, I just assumed you were just this evil person that got to decide what happened to me, and if you listen, they dialogue with you and they see that you're interested in what's going on with them in their life and what their feelings are. That's them and us.
And if I just want to say, I think at the end we should let all of the 3 stars that are here, I do think we should give them a round of applause for not only having gone through this, but being here to tell us. Not only do they go through this experience and all of the things that go along with that, but they've been here and been part of the video and part of the Foster Youth Council, and they're here to, throughout this conference to give us their perspective. And it's very important. That helps us all to know exactly, because most of us don't know what it's like. We can't appreciate what it's like to go through what you all have been through. And it's very, very helpful that you're all here and share your insights with us. So I think we should, like we do in a court hearing, say anything they want to say.
I guess just thinking through that, I know it's working on the job, if there are no people on the program, but I really appreciate you sharing some of your work. We appreciate that very much. You guys could possibly fathom, but it's big for us, especially in foster care and the things that we see. Just the importance and sense that we get from being there. Oh, my judge does care about me. She does want to see me because she does care. Or whatever the feeling may be. It makes a huge difference in somebody's life to know that not only that they're in foster care and they've seen some bad things or done some bad things, but that they can